Here's important information from the health law firm.
The end result of a hospital medical staff peer review action is often a hearing for the individual physician being reviewed. The term fair hearing is a term of art used for the internal administrative type hearing held by the medical staff of a hospital or by a professional association. It is supposed to be fair because it is supposed to include the following rights for the physician who is being reviewed. Due process, including detailed advance notice of what is being charged. The names of the witnesses against the physician so that the physician can prepare. The evidence that will be used against the physician at the hearing, including documents, medical records, reports, etc., in sufficient time to prepare a defense. The right to question any witnesses against them at the hearing. The right to introduce their own witnesses and evidence at the hearing. And the right to be represented by an attorney at the hearing. Implied in the foregoing is that the physician being reviewed should have an adequate amount of time to prepare properly to defend themselves. In order to properly defend in a peer review fair hearing, one must know how to organize and present evidence, both documents and the testimony of witnesses, clearly, concisely, and effectively. Someone who is not a lawyer and is not experienced in such hearings will rapidly find themselves in over their heads. The peer review process may be slightly different for every hospital, with the rules set out in the medical staff bylaws or written policy and procedure statements. However, it should include all of the rights discussed before. To be emphasized is that the hospitals and the medical staff's resources and access to evidence may be virtually unlimited, while those of the physician are very limited by comparison. It's important to understand that a fair hearing is not necessarily fair. If hospital administration, including nursing staff, or your economic competitors on the medical staff are out to get you, you will be gotten. It may not matter what the peer review or fair hearing committee recommends if the hospital and its administrative staff are against you. However, for a fighting chance, you must have an experienced advocate familiar with these hearings representing you, especially in a case where many patient records are being reviewed and the allegations appear to be serious. Then it is most important to retain an experienced healthcare attorney at the earliest opportunity. If you receive an adverse decision from the fair hearing, the consequences will be lifelong and career-altering. Board-certified health lawyer George Indest says, contact an attorney as early as possible in the process and begin preparation for a hearing. Then you will have the best chance of coming out of the peer review without problems. There may be other options and alternatives available early in the process, but only an experienced healthcare attorney familiar with peer review matters will know them. Contact the attorneys at the health law firm at the earliest sign that you may be the subject of a fair hearing. They have the experience you need.
For more information, visit thehealthlawfirm.com.